Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Okay, so here's what was supposed to happen. Welcome to Justice TV. Michael Bryant here. Hello, Linda Kenney Baden.
Hi, Michael Bryant.
So we were going to come on, pop on, and I was going to say hello, of course, and then pose a couple of questions. Will Kelsey Fitzsimmons be getting out of jail in the next few days? And what is going on with Mark Sanchez, former Jets quarterback, now indicted and stabbed? And then you would have heard the open, but I kind of, the machinery of StreamYard took over my body, and so I fixed that for next time. So anyway, that's the two things we're going to be chatting about.
That's right. But before that, we do have Rip and Read, Michael Bryant.
I believe we do. I believe we do. Okay, so you want to begin? You want to begin with one?
No. Okay. No. Okay. Actually, yes, I will begin with one of them, and this has to do with the judge. And I'm going to add this to the stage. I just want you to see this.
Oh my gosh!
Sometimes a picture is worth 1,000 words. This is a South Carolina judge. Her name is Diane Goodstein, right? She is a major judge. She is a top judge. She had a 4-bedroom, 4-bath, 1.155, 2 million home that went up in smoke about 11:30 the other day. A local resident could capture it from a drone. This was an explosion. This was likely an arson. Her husband, who is also a little bit older, said that he had apparently jumped off the 2 stories. Apparently, he had severe injuries, broke arms, legs, pelvic bones, all sorts of stuff. There were allegedly children in the house, grandkids in the house. The judge happened to be walking on the beach, but I believe it's in Edisto Beach, for those of you that know South Carolina. And indeed, there is a working theory that this is a payback. What is it a payback for? Potential arson linked to death threats she's been receiving after her September 2025 ruling blocking the Trump administration's access to voter registration data, which was then overturned by the higher court. But in any event, this does look like retribution. This does look like revenge. And I'll say it, no matter what party you are, violence is not the answer. So
you're pegging this as political violence. I guess we will wait and see what the ultimate investigation shows. She's a judge. I think it's safe to say that many folks have issues with judges over time, over the severity of a decision. That's it's wrong. It's extreme, but I can't wait to see what the investigation reveals about who did it and what their motivation was. That is a dramatic photo. Okay, so in the less dramatic realm, give me by burning building. Ghislaine Maxwell, remember she reached out to the Supreme Court. I say reached out like she just called them. She filed a request for a review of her case. Again, 20 years she was given for her role in the Jeffrey Epstein trafficking, et cetera, et cetera. She's been in about 3.5 years now, 4 years. And she was arguing that the deal that they made in South Florida to release or hold harmless any co-conspirators, named or otherwise, would apply to her situation in New York. All of the courts in New York said, no, conviction upheld, conviction upheld, conviction upheld, goes to the Supreme Court. They did not decide on the merits, and we talked about this before. I didn't think they'd ever get that far. They did not. They basically just said, we're not getting involved. They only get involved at the Supreme Court level when one of two things happens. It's an issue of first impression, or there is a conflict sort of evenly divided amongst the states. Not the situation here. No courts are arguing that a federal order in one district is applicable to all other federal districts. And so the court said, enjoy your time off.
Right.
Who knows?
Recently, when there was a decision on that particular issue in terms of stays, which I said the same thing.
And now we're going to find out, if she gets a pardon or something else. She's already been given what many believe is favorable treatment for having that 2-day conversation, right? And then they move her to a cushier federal location in Texas. maybe that's the next step on the way to pardon. Don't know. Okay.
Anyhow, we are going to ask David Oscar Marcus, who is her attorney, to come on the show. Missy will be reaching out to him, and we'll let you know if he appears, because we would like to have that conversation.
Yeah, definitely. Okay, your turn.
Okay. Okay. So we talked about that. Next, Sandra Birchmore, Farwell.
Ah.
All right. We'll probably do an episode on this that we'll post probably over the weekend because it's kind of important. Guess what? There was an order entered today. Initially, it was supposed to be a hearing. Remember, he's supposed to come to court and there'd be a pretrial hearing. He hasn't been in court since last October. Everything's been adjourned. And it's a motion that was agreed to by the government. And it's called an assented to motion to modify protective order. Now, what does that mean? That means that in addition to, by the way, I should mention, firing or terminating one of his lawyers, a woman named Jane F. Peachy, okay? He wanted to be able to review what they call cleaned up versions, and I'm not quite sure what cleaned up means, of Sandra Birchmore's phone and laptop data with any inappropriate pictures or videos removed, because in prison, you're not supposed to be looking at those type of pictures, right? And this would happen at set times with the government is set in a special room. You can't print, he can't copy, he can't write down, and he can't take any information with him, but he agrees to look at them. Now, whether that is to help him eventually, shall we say, give information in the future, or to help him with the defense of his case, we do not know. But we're going to keep our lookout and eyes and ears on this, because as you know, the Sandra Birchmore case, the feds charged Farwell with the murder of a federal witness because Morrissey, you know him, you remember him? You know, Polk County in Massachusetts refuses to consider this a murder, a homicide, something done by Farwell, and therefore the state of Massachusetts does not recognize that he is a suspect, but the feds do. So we'll keep our eye on that.
That was such a weird order. They originally had an order in place that they both agreed to. Defense said we did it because we just wanted to move the thing along. And the key difference was that he alone could not be looking at these materials. He always had to have an attorney with him. And now he's gone in, and with the government's approval, they said, okay, you can look at them by yourself now at these predetermined times. And they, there are things like autopsy photos, hospital photos, things that they have. And I think what he wants is, because they've blurred the faces and other things, I think he wants them unblurred so that he, for his purposes, his defense, theoretically, has a chance to do all that. Okay, another case. What a shock. It's in Massachusetts. I can't believe it.
Another Massachusetts case. What a shock.
On your calendar, I know you checked your calendar 2 weeks from today, October 20th. What's supposed to happen? Brian Walsh.
Brian Walsh.
Brian Walsh. I'd be shocked. Because he is now in the hospital for a 20-day hold.
He's in the loony bed.
To check his competency to stand trial. So that was never raised before. It's a nice little twist to this story. Unless they intend on holding trial with him monitoring remotely, obviously that's not happening, because there's going to be a report at the end of the 20 days saying he is competent, he is not competent. And remember, competent is not cuckoo. Competent means your ability to understand the charges against you and assist in your defense. That's the standard. That's all. You can still be cuckoo, but that's what you need to stand trial. And there's been no suggestion he isn't able to do those things. But now look for the new trial date. There's not a chance in hell it can go forward on October 20th.
Yeah, no way. But can I ask you one simple, stupid question from me? Who did this? Who moved for this?
Who decided that he might be non-compos mentis?
Right.
Yeah, well, that's a good question. He would have been sent to the hospital on somebody's suggestion, direction. And I doubt it was the prosecution. So who does that leave? That's my thinking. It's got to be the defense looking for some time. Remember, there's still that weird thing overhanging with the federal case and the documentation that everybody wanted to see, the stuff that helped the Karen Reed case so much, the Brian Walsh case,
and the Warhol case, which has already been pled, right?
Which one?
Andy Warhol. That's how this whole thing. Remember, he was doing dupes.
Oh, the federal. Yeah, that's a whole other issue. He has federal. He's taken a deal, and he's incarcerated for art fraud, which is interesting. And so that has some interplay with what's going on in the state case as well, not to mention all of these documents that the defense wants from the federal investigation, which were not destroyed. That's all we know at this point. They were not destroyed, although they were supposed to be at the end of the Karen Reed case. So much more going on in that case than, I mean, we're not even talking about the facts of a gruesome murder. We think, right? We think it's a murder. There's no body.
No body, and there was like a skull fragment.
Yes, I know you seem fixated on that. I think that might be from the household you're in there, just having dinner conversation with Dr. Baden. There was a piece of bone in the saw.
I actually have a factoid for you. Okay, I have a factoid question for you because you are so smart. All right, he's going to Bridgewater. What famous serial murderer was in Bridgewater?
I feel like I just looked at something about that recently, like in the top 10
I'll get
murders.
a nom de plume. Like a nom de plume. Now you don't have to give the actual name.
Okay. I don't know.
He was represented by F. Lee Bailey.
Okay. Murder case, right?
Murder case. I helped exhume the alleged serial killer and also one of the victims, and we want to have his nephew that had hired us. Yes. Hey, Paula.
Somebody's got it.
You have it. The Boston Strangler.
Oh, the Strangler, of course. Yes.
Okay,
there's something about Bridgewater.
Maybe we'll talk about maybe if we get Casey Sherman on, he wants to come on the show because he has a new book out. We can talk about that. As a matter of fact, let me write a note. Missy, take another note because you know how we are notes. We all forget that Casey Sherman, the Boston Strangler, okay, and Bridgewater. Okay.
Is there a new book out? Is he still guilty?
No. It has to do with he writes murder mysteries. He writes murder mysteries.
So it's a
best-selling author.
Yeah,
and he was actually going to interview the juror number 1, in the Karen Reed case, but somehow things happened and it never came off.
Interesting.
It never happened. Okay.
Okay. Well, speaking of fiction, listen to this segue. Speaking of fiction, Kelsey Fitzsimmons, the 28-year-old who is sitting in jail awaiting trial or whatever resolution there is to her assault charge in the shooting that resulted in her injury. So I know we've gone through this in some detail with folks over the last few weeks. We've been on this for a while. I was camped out outside the correctional facility when she was there. So the newest wrinkle is that this petition was filed, and we told you it was going to be filed last Tuesday. I knew it was coming, sources say, and it was filed on Thursday, I believe. Might have even been Wednesday. Anyway, so this is very interesting. This is, it's to the SJC, the Supreme Judicial Court of Massachusetts. They do
which
things,
is their top court, everybody.
and they do things a little weird there. What a shock. In their appellate system, you can ask for a sole or a single justice. And I don't think that means married or unmarried. A single justice. And so, I'm sorry, anybody? I'm sorry, they're all married. We got nothing for you. So you can ask for a single justice because I think it's a good idea. It helps expedite the process, right? If you've got all these emergency hearings and emergency petitions filed, and you have to wait for 7 of them to get together, that could bog down the system. So Timothy Bradl has brought this matter for a single justice. I'm told that the DA's office is going to respond Thursday, and I can't wait to read that piece of fiction. That's going to come out Thursday. We'll definitely do something with that whenever we do get it, because I think
it won't
important.
Be a best-selling piece of fiction. Let me
I just can't wait to see what they come up. Just to give the bare, I don't want to even give the bare bones because this petition does it. We're going to go through it in some major detail here. We're even going to have some role playing. I don't know if folks may remember the judge in the case, Kathleen McCarthy Neer. She was a piece of work that day. Maybe she was having a bad day. Maybe that's just how she is. I don't know. I have no idea.
I'm not giving her the benefit of the doubt, but she is going to have a new judge on this single petition in the Supreme Judicial Court.
Yeah, it ain't going to be her. In fact,
I know about her.
I believe, I got to double check here. I believe there's a request in this petition to get rid of her. I got to double check. That was something I was a little
Yes, there is.
surprised
There's
to
a
see.
request to get rid of the judge, and it's going to, just let me tell you, Judge Elizabeth, and I'm not sure if I pronounced her name, Dewar, Dewar. Those in Boston can tell me if that's the case. She was, just so you know, when we go through this petition, so you can think about whether or not that Elizabeth Dewar is going to be, shall we say, amenable to it. She was appointed at the official oath in January 16, 2024. She was appointed by the Attorney General to serve as the state's second state solicitor in 2016. And I'm taking this from a news article. Quote, in her role as state solicitor, she supervised the briefing and arguing of appeals by attorneys throughout the Attorney General's office in the Supreme Judicial Court, as well as other state and federal courts. She advised the Attorney General on exercising her authority to decide whether to appeal adverse decisions, and led the office's, quote, friend of the court amicus practice, among other responsibilities. She also briefly served as Attorney General in 2023. As state solicitor, she served ex officio as a member of the Supreme Judicial Court Standing Advisory Committee on the Rules of Appellate Procedure, and previously worked at a firm called Ropes and Gray. Well, that doesn't do well for me here, because Ropes and Gray was the firm who actually got Aaron Hernandez convicted on his first trial. So that didn't go. But she was a law clerk for, she's smart, all three members of the federal judiciary, the Supreme Court, the Court of Appeals for the Ninth Circuit, and the Court of Appeals for the Eastern District of Pennsylvania. She earned a bachelor's degree from Harvard, a master's degree from University of Cambridge, and a law degree from Yale. So, shall we say she's got a little more chops than the trial.
Well, then she has no excuse for being a moron, as she was in this particular case. So,
well, no, she's not going to be the moron. She's going to be the judge. She's going to be the judge that's going to be hearing.
Oh, she's the single justice.
She's the single justice.
It's already been assigned to her. I did not know.
That's what it says. That's what it said. That's what your
sources are telling you.
Yeah.
Well, I'm glad.
So I don't know, but that's, if not, I've just wasted 3 minutes of our show.
Yeah. Well, I'm deferring to your sources on that one. I did not hear that. Let me answer this real quick. Kyle Sharkey, are you heading to Aiden's hearing Wednesday afternoon? I talked to Aiden. We exchanged some messages. It's a non-event. In his words, it doesn't affect us, and we're not going. So that's all I know about that. So okay, here we go. This is really so fun and well written, and I say fun in a weird context, just from a legal perspective. There's so much to work with, and Tim Bradl did a great job here. Ms. Fitzsimmons had come back to court on her own motion through counsel after she was unable to blow into a Scram alcohol monitoring device deeply enough due to her sustaining a gunshot wound to her chest. I mean, that's the guts of this. We'll get it all, postpartum depression, and she lost her badge and her right to have a gun, and then it was reinstated. She was going to be going back to work on July 4th. This happened on June 30th. And her fiance, baby daddy, knew all about this timing. As we see this unfold, we'll learn that he went in ex parte, got the order to have the child removed, saying that because of her postpartum depression and some sort of suicidal ideations, that he was helping the baby, get that baby out from this woman's custody. That's kind of the setup for what led to the altercation at the time this happened at the house. I looked up, remember Scram? We did a little piece. And if you guys wonder what Scram looks like, how it works, check our library. We did one on there where we're actually showing how it works. They kept talking about installing it. It's going to be installed. It's going to be, and I thought, are they doing some sort of invasive, I'm thinking like a pacemaker or what? Installed is kind of a term of art. It just means you're in the system on the computer, and that the programming of the device is installed so that, if you have to do it 4 times a day or randomly or whatever it may be, now you're installed in the system.
Okay.
And she was installed. Okay. So this is what the single justice, I still think that's funny the way it's phrased, wants from this particular petition. Address the bail determination de novo, which is so important here. Why is that important, partner?
Because it means from the beginning, you don't look at anything that's been done in the past. You take a look at it yourself as the single justice, and you make a determination, and you don't give any due deference due deference to the court below, which of course
Yep.
I think the
It
court
basically
should.
means, I think literally it's of new, something like that. And the key is you can look at stuff outside the hearing. You can
Right.
have additional information, which is pointed out by counsel.
Like us calling the judge an asshole. They can look
Yeah.
at that.
Yes. Yeah, I call her a bitch, but hey, okay. Grant Ms. Fitzsimmons liberty with personal cognizance and a stay away order under Section 57. 3, or any other such non-incarcerative relief in the alternative if the single justice deems 58A conditions are necessary. And those are the conditions set up when she was first arrested and released. One of the conditions was scram. Okay. Here's the key. 4, send the case back to the Essex Superior Court before a different judge, for a different judge, for the reasons set forth below. And for those who didn't hear that audio, we played it back when it happened. It's unbelievable. I mean, I wish we could see it, because I'm sure if her mannerisms match the tone of her voice and her sarcasm and her petulance, it's ugly. It's got to be ugly. Okay, so she goes off with her conditions under bail. Got to do the scram. And remember, this is key. At the hearing, the probation officer testified, and he testified, I never said she violated. They came here voluntarily to get a change because this deep inhalation and exhalation hurts the ribs that have been shot and broken and fractured. And even the surgeon, surgeons are tough to, get their time to do anything. The guy wrote a letter to the court, and she basically ignored all this stuff. So let's look at the testing itself. She passed 8 out of 9 tests. Okay, so that you might think, ooh,
Wow, that's interesting, right?
Yeah, but you might think, oh, well, you got to pass them all, right? So talking about the 9th test, between the physical pain and the anxiety of warrants issuing, causing her to be arrested and taken to jail despite her good faith attempts, Ms. Fitzsimmons, through counsel, returned to court right away of her own accord. And she tried about 4 different times on this 9th attempt. And finally, to the probation officer's satisfaction, she passed. Okay, so there's not even a violation that you can hang your hat on. She just had trouble with the 9th one because of the breathing. And so here the defense goes to court. They're making their arguments. They were greeted with hostility, interruptions, and we're talking about from the judge here, folks, not the gallery. Hostility, interruptions, obtuse posturing, presumptive skepticism, willful blindness as to the availability of other methods of testing, and grossly injudicious behavior, culminating in the court walking off the bench during the middle of the argument of undersigned, Mr. Bradl. And you'll hear it if you listen to that audio. And she makes it sound like, okay, I'm going to take a break. And just before that, she said, is that it? Is that all your arguments? That's it? It's outrageous. Here's the probation officer. Assistant Chief Probations Officer testified that he saw Ms. Fitzsimmons could not take the test without severe pain and discomfort, and that he was not seeking to surrender her or assert that she was in noncompliance. You got to defer to the probation department, at the very least, Judge. So the court, McCarthy, Naaman, sua sponte, I have to admit it's one of my favorite Latin phrases.
Right, on its own, sua
yep,
sponte.
Without any sort of assistance or effort by anybody else, did it herself, denied the request for an alternative method, and revoked her terms of release. The judge sent the seriously injured police officer and former corrections officer to jail for 180 days as a danger to the community because she couldn't blow into a breath testing device intensely enough without causing pain and dizziness and aggravating her broken ribs. And let's go to the footnotes. Footnotes, what do they have? They always have the good stuff, right?
Right. Although I was taught as a lawyer, if you've got
not
really
to
good
use
stuff,
them.
Don't put them in the footnotes.
Yeah.
Put them in the brief.
Yeah. And it's really just a matter of form. It's not like it needs to be in a footnote. The court ignored the increased risks inherent in incarcerating a police officer and former corrections officer. The defense learned on September 28 that Ms. Fitzsimmons had, in fact, been targeted. Listen to this. At the Chicopee Women's Correctional Center, where that's one of our remote locations. 9:15 a.m. on the 24th, a biological male, don't get me started on who gets to go to jail if you just say you're a woman, identifying as a female, threatened petitioner, saying in her presence, I found out something about that bitch, and later, directly to Ms. Fitzsimmons. While walking to his cell, he began pointing and screaming at inmate Fitzsimmons, who was currently on the rec deck, and stated, "You PC bitch, you best check out who you're fucking with."
Oh dear.
Yeah. Yeah. So, I mean, common sense tells you a former CO, former cop in jail, nothing good's going to happen. I'm most afraid that she's going to be injured or worse while this is playing out.
Right.
I mean, I think every day is life-threatening to this woman. She is under enhanced risk of harm and even death, and should be released forthwith. I like a nice forthwith put in there at the proper time. Ms. Fitzsimmons will not plead or admit to this charge. Again, the only charge that's remaining is the assault charge. They tried to get her indicted on intent to murder, and the grand jury said, "Get out of here." And that doesn't happen very often.
And for those of you that don't know the backstory, because maybe people are joining us and don't know the backstory, right? She's about to go back to work. She has a 5-month-old baby, right? Her boyfriend, who was supposed to be her husband in October, gets a unilateral restraining and taking away the baby on the basis that she, even though on June 30th, she was cleared to go back on July 4th, could be a danger to herself and the baby, because she said she was going to take the baby in like a faraway place, which he interpreted that meant that she was going to kill the child. So unbeknownst to her, he says, "Where are you going to be on this time?" And so she goes to meet him, and not there, right? And then she goes back to the house, and nothing, no calls, no contact. And then her own police department storms in and takes the baby from her. She, had just finishing her postpartum depression, was cleared to go back in 4 days, but clearly still very upset. Went running upstairs, tried to take a gun and shoot herself in the head, at which point her police department partner actually shot her in the chest, where bullet fragments still remain.
Yep. So somebody had a question here that's germane to right now, so I'm going to bring it up, perhaps out of order. Oh, wait, but first, we have to do this first. Linda, Cynthia Lynch.
Thank you.
Thank you. And of course,
thank you, Cynthia Lynch.
Thank you, Joey Kane.
Yeah, thank you, Joey Kane. Thank you, Cynthia Lynch, because after this weekend, some of these comments I've seen on people,
as I say, there's far more love than hate for you out there,
yeah,
partner.
thank you. And thank you, Joey Kane. Joey Kane, we got your email, and I'm going to look into that. I want you to send me more. We are doing something. This
another
is
Joey Kane.
Yeah, we're interested in interrupting this in a second, because we have a show called Justice Served TV, The Hunt. We're putting a second thing up next week with regard to finding who killed Stephanie out in Oregon back in 1968. We're asking people to send cases, and Joey did send a case in. And Joey, I want you to send more. That's all. I'll leave it at that.
Good job, Joey. Okay, here's a good question. Appropriate. First question you might think. If she's not drinking alcohol, why does she keep having to blow for drinking? Aha. This court, and apparently not unusual in Massachusetts, for virtually anybody held in custody to have that as a release condition. Okay. And although alcohol not involved in the incident that happened at her house that day, she had a history with some drinking issues, but they were, technically far removed from what happened this day. But again, that was something the judge has done, and apparently other judges have done as well, almost as a matter of routine, figuring, drinking alcohol may not help your situations. Why don't you just not do that? So that's why it is not imposed as it was imposed, and why this whole scram thing even, happened. Obviously, if they hadn't imposed that, we wouldn't be having this conversation.
Right.
So Ms. Fitzsimmons will not plead or admit to this charge, the one that remains, and has always asserted that she did not assault anyone with her firearm, but rather engaged in only a half-hearted attempt at self-harm, putting the gun to her head. The hypothetical disposition is noted only to underscore how the satisfactory seriousness of the offense impacts what a proper bail determination would be. This relates to the fact that one charge that remains is a relatively low-level felony, 5-year max, and somebody like Ms. Fitzsimmons with no priors and no history is probably going to get probation anyway. So that relates to, well, how important is it to have them incarcerated pre-trial if there's a very good chance they're not going to be incarcerated even if convicted, or if they take a plea, right? Let's see. The order required Miss Fitzsimmons to surrender her 5-month. You set up the premise for this perfectly. The order required Miss Fitzsimmons to surrender her 5-month-old to the fiance and surrender her firearms to police. In the space of 30 seconds, Miss Fitzsimmons, upset by the events taking place, realized she had been betrayed by her fiance, who had filed a false and self-serving affidavit after disappearing for 3 days. She was actually going to the park, supposed to meet him, right? And she hangs out for a couple hours, whatever, and he never shows up, goes home, and that's when the cops show up. So he's setting her up all along. Now, I'm not going to say that he didn't have some legitimate concerns, because she was struggling. I get that. But to do what he did, which led to this ultimate shooting and now her incarceration, is just too much. It's too much. Miss Fitzsimmons, being distressed due to the surprise restraining order and the bombshell just dropped on her, raised her firearm to the side of her head in a half-hearted attempt to inflict self-harm. She put the gun to her head. She was shot in the chest by her former partner friend, Officer Patrick Noonan. For those who don't remember, this guy was not just a fellow cop, right, on the North Andover Police Department. They had been they came up together. And they went on a call one time, which was a mother-child murder-suicide.
Right.
And they went to that scene together,
experienced it.
She was, and bonded over it, in one of the weird ways that you do when you have that shared kind of tragedy. So this was not just a guy that she knew in passing. The allegation of intent to murder, along with an extra assault charge, were rejected by the Essex grand jury. Good for them. And actually kind of surprising. The trial court's order is as heartless as it is legally baseless. It must be reversed. And so Mr. Bradl goes into quite a few legal arguments, factual arguments, talking here in this footnote about the Massachusetts sentencing guidelines. Again, for a probationary sentence, if in fact she were to take that deal, unless the court acts here, she will have to endure pretrial incarceration on a case where if she pled guilty, she would not, which she will not do. She almost certainly would get probation, which is what I suggested was this weird dichotomy of facts and law. Okay, so let's take a look at the bail statute, right? Remember, and this is so important, she wasn't violated in going into court to defend herself. She knocked on the court's door. Hello? Hey, hello? I can't breathe with this thing to give you the right result. What's the alternative? Let's have a hearing. And they do that. When you have one of those hearings, you're basically looking at the original order and asking for some sort of change, or the court's going to have to impose some sort of change. But here's what the law requires, and we can just look at it under 58A. A person who has been released after hearing pursuant to one of these sections. Okay, so she's been released, conditions have been set. If you're going to try and change that, you have to have clear and convincing evidence that the person has violated any other conditions of release and that the judicial officer finds that there are no conditions of release that will reasonably assure the person will not pose a danger to the safety of any other person in the community, or the person is unlikely to abide by any condition or combination of conditions of release. So Bradl is saying, the defendant is saying, the court did none of that. The court just kind of made it up as she was going along.
Right.
Ms. Fitzsimmons did not violate a condition of release. She was in good faith, trying to avoid difficulty going forward. The Commonwealth, to its credit. Now remember, that's another key point here. Commonwealth was not there pounding on the desk, siding with the judge. They're like doing the hands in pocket thing. Nope, we're good, judge. Yeah, we got nothing. So they're not going to argue for the defendant, but they're doing the next best thing. They're saying nothing, right? So it's worse than the judge being at the prosecution table. The judge is the prosecutor in this case because the prosecutor is sitting this one out. The Commonwealth, to its credit, recognized the situation as such and only wanted her to continue to be tested. When asked for its position or evidence, the prosecution said no evidence to submit other than the arguments that I talked about how the Commonwealth's belief is, in light of the court releasing the defendant, testing be done. That's all they said.
Right.
That was it. Okay.
And testing can be anything. It doesn't have to be the scram testing, although, there's a There's I just want everyone to understand there's contracts that exist in different municipalities, in different counties, in different states with different companies to do everything. And they say, okay, we have a contract. This doesn't cost us any more money than what's in our contract, right? To do it. But there's different ways that if she wants testing, they could even order her to pay for it, because I'll guarantee you she's paying for the scram testing.
Yeah, scram is not free. I'm sure there's some way to request a waiver like you can in any circumstance, but it's really not the way to go unless you truly need it. So I'm sure she was paying for that. And I'm sure she'd pay for any urine testing if that was the alternative that was granted. And I predict that's what's going to happen here. I predict that the single justice, I hope they find the right person, that the single justice will say, okay, she's going to get out. The alternative is urine testing. Let's just do that. Let's fix that. Okay, and we're going to have a little role playing here, and you're going to get to be the judge.
Oh, okay.
I
get to be the evil. I get to be the evil stepmother.
Put on your feisty and nasty. I will be playing the probation officer, right. Jeff January. Okay, so
where are we?
We're coming up on that. This is page 9.
I'm going to put on my reading glasses then.
Yeah, and I've highlighted almost everything, so that won't help you. But it is bold, and it shows court, and then that will be your line. Assistant Chief Probation Officer Jeff January fully supported an alternative testing means, but was completely shut down by the judge, who became increasingly angry that he was confirming and corroborating the defense motion with his own personal knowledge. So I'm now Mr. January. My first job when we get an incomplete test is to gather more information, which is what we do. So in response to the incomplete test, we call Elmo. I think that's the organization that gets all the information. That's all I know. We gather the information, which is she answered the alert to take the test as scheduled, and that's what happens. This device goes beep, 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 test now, beep, 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 test now. She was unable to complete the test because she was unable to blow as long or as hard as needed to complete the test. So ultimately, at 4:20, she completes the scheduled test. There may be additional attempts in between, but ultimately she completes the test. In conjunction to the hour and 20 minutes, we also know, and I observed it firsthand, that whatever the injuries are, and I don't know exactly what they are, it doesn't really matter to me. When I was doing the installation process, remember what I talked to you about that, and observed what genuine pain, court,
any objection to any of the terms used by the probation officer? No? Okay.
Yeah, and that was basically from the prosecution saying, I got nothing. We have all the information. We don't deem that, again, this is me, probation officer January. We don't deem that non-compliant. She's attempting to take the test. She ultimately passes the test at 4:20. So with all the information, that's not non-compliant. That's compliance with her obstacle. That's compliant with scram testing. This particular case, I don't deem non-compliance because she's complying with the scheduled program. I'm aware of pain based on my observations from the installation process. So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's...
Well, that's your position. That's a non-compliant. It's really up to the court to determine whether someone is compliant or not with the conditions of release.
The goal is to test to ensure that the person is sober, and we don't deem that non-compliance. We never have and never would, in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. The schedule for her to be tested is something that we discussed.
What do you mean we discussed? So she knows when she's going to be tested?
I discussed it with Ms. Fitzsimmons. I discussed it with defense counsel by creating a testing schedule because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency.
It was random screens. Excuse me, Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
Well, we created a schedule, as we always do. Not in this particular case. We always do.
It was random screens that were ordered.
When we get an order and someone is placed on pretrial conditions that include remaining alcohol-free with scram testing, we always default to creating a testing schedule. of up to 4 times a day. The only way we would not enter into a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming. I want the test to be done randomly. The court was incorrect. Oh, your part's done. The court was incorrect. Random and scene. The court did not ask for random testing. So here's the probation guy saying, well, the only time we do random testing is when the court specifically orders it. That didn't happen in this case. Okay, then we learn a little bit about Ms. Fitzsimmons, know all about her background. I didn't know that she went to a year of law school.
I didn't
And
realize
then she decided, it's not for me. I want to be a cop. And then she did the CO for 2 years, and then applied to the police department there, and passed and got the gig at North Andover Police Department. Okay, so this is a kind of a concluding thought in terms of her life and what she's been doing. She has been found by an expert clinician to not be dangerous and deserving of reunification immediately with a child. This is important because remember, one of the other indicators of whether she should be released is she a danger to the community?
Well, can I just interrupt you here? I know
yes.
Because I like the previous line. Like countless new mothers, she had suffered from transient bout of postpartum depression. And you and I had done a show about this. We've talked about Brooke Shields. We've talked about Princess Diana. We talked about a lot of mothers who have postpartum depression. Okay. And here's what happens. The reason why this is important, she's been found by an expert clinician not to be dangerous and deserving of reunification immediately. Because here's the game. Okay. The game is this. Dad and grandparents have the child, right? Dad has a child right now, maybe living with mom, maybe living with his parents, right? All of a sudden, months go by because the court process, and I've seen this happen, the court process is slow. And they say now, well, it's in the best interest of the child to keep the child with dad and his present living arrangement, whatever that is, and not go back to the mother and not have reunification. Or if you have reunification, maybe it's a visit once a month or once a week, and it has to be supervised. It has to be with people. But then ultimately, permanent custody resides with dad because the best interest of the child through the time is now given by time is decided by a court to be with the father. And that's the game. And that's why this little line here that Bradl puts in is extremely important because he's talking about reunification now. So that way that doesn't happen in the future, that some court like this one here that I had to, imitate and be the evil stepmother for.
Yeah, you were far too kind, actually. But
yeah, probably. Although I didn't feel it in my head. I mean, I don't want to lose my law license by calling her an asshole too many times because I'm doing it as a journalist. Okay, I'm not doing it as a lawyer, so I'm not demeaning the court as a lawyer. I'm demeaning it as a journalist here, and that's the game. Okay, and I've had that game. I actually won that when a child was taken away from somebody. I say it's the most important case I ever had in my life, pro bono case, who was in the Army and he was stationed in Panama, and then because the mother, the child had been taken away because the mother was a drug addict, the DYFS, Division of Youth and Family Services in New Jersey, said we can't go back to the father because the best interest of the child was to keep him with the new people. And we fought that. I got a pro bono. We fought that all the way to the New Jersey Supreme Court, and we won. Happiest day of my life when he picked up his child at Newark Airport and flew him back to Panama with him.
God bless you. That's probably a tearjerker when that happens.
It's when people say, "What's your most important case you ever tried or have done?" That was the most important case I ever did.
On that note, before we get back to this, and I appreciate that hard work, Sherry Schreiber gifting a Justice Serve TV membership, and remember, I guess I hadn't mentioned this. There's a hearing on schedule tomorrow for this case, right? But it's a pre-trial, status conference, and I've been informed that from the court, I called the court, Ms. Fitzsimmons will not be there. So, and it is, if you look at a map, I look at Chicopee on the far west of Massachusetts, the Salem court is on the water on the east. It's a schlep. It's a long haul. Not that she wouldn't mind getting, I'm sure, out of jail there, but she is not going to be appearing And I fully expect not much is going to happen. And sources are telling me not much is going to happen, but it's been on the calendar. It's just a pro forma hearing that would normally be, despite all that's going on, it would normally be on the calendar. So.
By the way, Sherry Schreiber, I will say, if you haven't checked out her episode that she did with us on addiction and dependency and recovery, it's in our videos to honor National Recovery Month. But as I say, every day should be National Recovery Month. Please go do it. Sherry spent a whole hour with us. She's absolutely wonderful.
Yep. It was great. She's so inspirational. So here's a kind of a backstory, which we've talked a little bit about. Ms. Fitzsimmons was scheduled to return to work on July 4th, the day of June 30th. Her significant other and baby father betrayed her with lies and false allegations designed to take her baby from her and extract himself in the worst faith and cowardly fashion imaginable from the relationship. Hey, don't forget, what has he filed since then? He's filed
a motion
to
get her
lien
house,
the property.
to lien the property.
He wants to put a lien on the property, and there's about $200,000 in equity. And he
for
thinks
future
that,
future child support, which tells you exactly what we were just talking about, that he's expecting the future child support was he has the child because he expected them, and I use them as the courts of Massachusetts to say it's in the best interest of the child to stay with them.
Right. And it just makes it look like a master plan, that he was unfolding there with or without. I believe he lives with his parents, and the child is with them as well. So he, I guess, doesn't have the means to be on his own either. So I guess he's looking at this as a way to get a payday. Let's see. He told her to meet him at a local park, instead stood her up and the baby, and instead went and got the ex parte restraining order. And I love this. That's why I put it in green. Unfortunately, the department's decision to avoid body cameras leaves the case as he said, she said. Why do you want to avoid it? I don't even know how you explain that away. Yeah, they're kind of a pain. I don't know why, with the technology and the price these days, you can get a body camera for about $50, right? That Axion system.
Right.
I don't know how any police department excuses not having body cam. It's just outrageous. Let's see. This is just a footnote ragging on the court's use of misuse of the statute. And again, the statute being the one that affects the initial released conditions and then evaluating them to make a change. Use of the statute in such a manner shocks the conscience, which is, when you're in law school, that's one of your favorite phrases. That comes down from on high. If you hear shocks the conscience, you better have the goods to back it up. And it is beyond all norms in a nation of ordered liberty. It is time for the SJC or legislative reform of the abuse of Chapter 209A. And 209A is the way to is what this fiance did, the ex parte order. And what Bradl is saying is it is so abused that the legislature needs to fix this. Now, he's not asking the single justice to help out, but he's making the point that this is constantly a problem. It needs to be fixed at the highest level. Mm-hmm. Let's see. Oh, this is interesting too. The other thing that you're now the judge in this case, what she failed to admit was that
she's a witch who doesn't dress well. She's never going to be me, and I'm never going to be her.
That's right. I have to agree. She made a point of ignoring certain evidence, including the doctor's note I mentioned, the surgeon's note, saying that's hearsay. Well, what she's ignoring is the fact that the law regarding procedure for these kinds of reconsideration motions, if you want to call it that, or these attempts to get conditions changed, they don't follow all of the rules of evidence. It's not a strict hearsay analysis. She is allowed to look at documents that might otherwise be inadmissible if it were a normal trial. And that's codified. That's what it says. The court apparently forgot that. In fact, at a prior hearing, the court suggested, and the defense agreed, that the facts in the prior filings could be incorporated by reference, so all the facts could be before the court. In its ruling, the court apparently ignored this position, claiming a lack of medical evidence and a lack of specifics on simple urine testing that is ordered and or referenced in court likely every single day and undoubtedly utilized by this very court over her several years of experience. So that just means the court is allowed to basically take judicial notice of other information that's come in prior hearings. She didn't do that. Let's see, what else didn't she do? Oh, the September 11 hearing, the motion for relief. That's the first one that led to her reincarceration. The court incorrectly stated it had no medical support, whereas defense counsel had submitted a medical notice to the court prior to the petitioner's initial release on September 8th. So she's just ignoring all of the history in this case. It's like she's looking for a result and then trying to figure out how to get there. If her goal was to get her back in jail, how do I get there?
Yeah, as far as I'm concerned, there should be a look to see, and I don't usually say this lightly, at ethics with regard to her continuing on the bench. Certainly, Mr. Bradl's never going to be able to practice in front of her, but
Right.
this is outrageous. And we're staying on this. I mean, let's continue on. I mean, I just the more I hear about
It gets
this,
me
every
so
time I hear
mad
it,
just
I get
going through the
upset.
details of what she did that day.
Right.
And I'm telling you guys, if you have not listened to the audio, I believe that's all there is available. I hope that's different next time. But if you look at the audio, listen to it, it's crazy. The court was aware as early as the second hearing on September 8th that Ms. Fitzsimmons had difficulty breathing due to her healing punctured lung and broken ribs.
And she's got shrapnel. She has
in her back,
bullet
still up there.
fragments in her back. She still has bullet fragments, everybody.
And she ignored the court affidavits, had the defendant and the family, and 2 reports from a psychiatrist and a psychologist. All of that ignored. Dr. Parks, I believe, was the surgeon. He corroborated petitioner's medical notice, her mother, and the ACPO. What's the ACPO? I forgot. And opined, in my medical opinion, a fracture of the 12th rib can cause pain that may persist for several months after the injury. The severity and duration of pain following such a fracture vary, and it's difficult to predict how long symptoms will continue in any given patient. Additionally, retained bullet fragments can also cause chronic pain. I hate when that happens. And it can be exacerbated by movements such as deep breathing. Again, court ignored all of that. And then, started ragging on the defense when they got into the alternatives, right?
Right.
They're talking about the scram. The urine testing is a common tool used by the trial court every day, not a complicated or obscure request by petitioner. Counsel did, in fact, reference testing alternatives at several times during the September 11 hearing. Unfortunately, the court's demeanor severely curtailed any elaboration from probation or counsel, culminating in the court preventing any further discussion by walking off the bench mid-argument of the undersigned. And I wish I could see that play out because it sounds weird just on audio.
Right.
It's like she was going through a drive-through window and just picked up her order and left. It was just weird. The defense requested alternative testing, which was readily available, and reserved specifics for later to avoid further enraging the court. So he could, you got to read the room when you're an attorney in one of these hearings, right? Now, this lady's off the charts in terms of how you're going to finesse her or try to get to the best resolution. She was not reasonable. And you're never going to win an argument with somebody who's unreasonable. But he was trying to figure out, how do I make this easier and make it still work for us? So he didn't get into the details on the alternative testing. And then she held that against him.
But Michael, I like, and you didn't highlight this. Could you stop right here?
Well,
Go back. This is the argument that I said should be made last week. The court violated the Americans with Disabilities Act. Now, if
I think
my case, we're going to talk about it. If I were doing this, I would have filed at the same time. You can't right now because the courts are kind of shut down. A petition, a habeas right away, a case right away in the federal court right there for violation of the Americans with Disabilities Act. Now, it's not a good time because we all know that there's no funding right now and there's a shutdown. But you can get relief because it was outrageous. Aside from everything else, it was outrageous that this court decided on her own that she was doctor, nurse, probation office, executioner, police officer, father, grandparents, and all around witch all at once, without even considering the fact that there could be an alternate explanation, an alternate accommodation under the ADA.
I don't understand it. I mean, as I'm watching it or listening to it, and I'm just thinking, why is she so pissed off at this officer who's now a defendant? Why?
Maybe that's a $664,000 question, right?
I tell you, Cynthia, she was planning a standout tomorrow, but no Kelsey. What will take place? Yeah, it sounds like it's going to be a pro forma hearing, according to counsel, and the clerk's office saying that Ms. Fitzsimmons is not going to be there. And I said, not even by video? Nope. So those things get put on the calendar as a matter of, it's a program, complaint filed on this day, and then it kicks out all of the normal hearing dates that would follow. But this is this is through the looking glass, people. This has got so many other things going on. I don't think that hearing was ever really reinforced. Probably should have been removed, but it's on calendar. So,
but you can still protest. You can still protest at the courthouse where the judge is. You can still do a stand protest where she's sitting. You can still, register your complaints.
And Mr. Bradl may be there. I have not confirmed or gotten that confirmed or not. But it sounds like there's something happening. It's just the defendant will not be there. So if the defendant's not going to be there, it's not going to be all that substantive. It might just be a procedural, it's a status check.
Maybe it'll get reversed because it's all the publicity that is.
Well, the timing is interesting because the DA hasn't even weighed in yet. They'll weigh in on Thursday. The hearing is on Tuesday. So unless the prosecution of its own volition tells the court, look, we're fine with what we talked about doing, and fixes things before they even have to respond under the SJC schedule, that's the only way I can see it resolving.
Ring a ring for the chief judge of the location. Excuse me, underling.
Essex County.
Excuse me, underling. You fucked up, okay? Fix it now, okay? Let's not assume that can't happen. Okay.
Yeah. Zoe B, Oasis Cat. Hello there. Glad to be here today for a live. I see they passed 30,000 finally on their way to the next milestone. That's right. Oh yeah, that happened. It happened over the weekend. I forgot about that.
I know this is a compliment.
New balloons.
New balloons. I know this is a compliment. We actually did it in 1 year and 3 weeks, which apparently is some kind of really important milestone to do that. And it's because of all of you. We asked you all, please hit that subscribe, like, share, notify button. And boy, did you do that. And, Michael and I, we're not afraid to speak out. The one thing that we think makes our show different, we're not finished, by the way, we got a lot more to go here. Our show different than everybody else is that we believe in morality. We believe in ethics. We believe in telling you like it is, whether you like it or not. And some people don't like it. Usually they'll talk about how they don't like me, but that's okay. They love me. Okay.
I'm part of the furniture. I'm just here.
Yeah. So let's we want to thank you all for that. And I just say that I did because I knew this was going to happen. The day when I was at the grocery store. Yes, I go to the grocery store. But see this, the word to believe. You know what that's from? Thank you, Madeira Beach Caregiver Gifting 10 Justice Served. That is from a show called Ted Lasso, who they now have.
Let me get that full so people can see that better.
They believe, right? We believe in ourselves. We believe in you. We believe in our viewers. And I bought this specifically, Ted Lasso biscuits with the boss.
For those who watched the show, or maybe didn't, he would give a little teeny box of biscuits. That one is on steroids there. He'd give a little box of biscuits to the boss.
It's so good.
Hold it up a little bit more. So is it like a biscuit or
it's like a biscuit. It's actually like what I had to say. I had to have
looks like
one.
You got cheated in that box. Like
some missing. It was saying already.
What happened?
It didn't quite make it down here intact because I had to. So we believe in you, and then I'm going to celebrate with biscuits afterwards. Probably tomorrow morning, maybe in my dirty matcha.
There you go. So it's it's a scone-like thing, maybe, or something that,
but
or
these are delicious.
or something.
But it's but it's delicious. I mean, I have to tell you, they were delicious. They're right next to Malamars.
That's dangerous. Okay, here's I have tennis tonight, so I can't stay too much longer.
We got another thing.
We got to do Sanchez. So we'll wrap this up with. I do believe the ADA reference was just great lawyering and great research. Right. They're basically saying that because she is now disabled as a result of the gunshot wound, that she should get the protections of the Americans with Disabilities Act.
Right.
And that act applies in all public or judicial proceedings. Mm-hmm. So they've taken that and kind of molded it and asked, it's clearly an afterthought. It's, page 20 of a 22-page.
It may be an afterthought for them, but it's
petition.
not for me because that's what I did. I do a lot.
I
of
appreciate that. And I think it's, is it going to tip the scale? I don't know. Maybe, if that's what the court wants to sink its hooks into.
Maybe, especially if this goes up further and you want to start getting some amicus or amicus, depending on how you pronounce it.
Yes, I like amicus. I'm not quite sure why.
Yeah. Anyhow, we do have another case we want to talk about.
Yes, let's touch on this real quick. Let me get rid of this.
We want to touch about, and then we're going to do a whole, maybe a whole show or a whole half a show on this because this is a fascinating case.
Yeah, a whole partial show.
Well, this is a really fascinating case, and we're going to talk about it. It not only is an amazing case, but it's an amazing case because we're talking about a football player who was the quarterback for my Jets, of which I dug up a 2014 tweet, which we'll use in our next time we talk about it. I'm going to keep you there because you're going to be wondering what I said back in 2014, 11 years ago about Mark Sanchez.
Yeah, I read that. And so you're bagging on the guy even then. You're bagging on it.
But no, you just gave it away. But we won't exactly. We won't exactly.
Well, who doesn't bag on former, Jets players?
But this is something that everyone thought that Mark Sanchez had been stabbed, right?
Well, he was stabbed already.
He was stabbed already, but they thought that he'd been stabbed. And when you first heard about it, some kind of he's in Indianapolis, some kind of robbery or assault.
Yeah.
He is now he is now a felony defendant as of today. All right. And why is that? Okay. Because apparently there was an altercation over where some gentleman who's 69 years old was parking.
Lisa was asking, the guy's a grease truck driver and said, what's a grease truck? What? Well, as a veteran of McDonald's, a manager there are companies, their job is to suck the dirty grease out of the pits used in kitchens. In this case, it was right by the Marriott and a couple of other hotels. So he's going by using that honey wagon and taking all of the grease that is used, and they recycle it and they try and, use it again. And that's what he's doing there. And he's parked in the alley because that's where he does his grease thing. And for some reason, an apparently intoxicated Mark Sanchez is running wind sprints in the alley. Now, I don't know why a guy who's been drinking is going to be running wind sprints in the evening, but he felt the grease truck was in his way. That's what led to the confrontation. Okay, pick it up from there.
So they get into an altercation, and I don't have, and I'm not going to put up the picture of the victim.
No, it's brutal.
It's brutal where the victim, because Sanchez keeps coming at him, but actually sprays Sanchez with a mace type device. It doesn't do anything for whatever Sanchez is feeling, on, not on, thinking that he's right, whatever, and then ends up having to stab Sanchez in self-defense. And Sanchez is there's video of him being drunk, walking around.
We happen to have that.
And we happen to have that, right?
Yeah. And so what I think is interesting too, among other things, is this 69-year-old guy, he's hard of hearing, right? So he uses hearing aids, but during this grease sucking process, it's loud. Mm-hmm. So he takes out his hearing aids. So when he is accosted, at least verbally, by Mr. Sanchez, he can't really hear him because he's got the hearing aids out. So he's getting close to Mark Sanchez to hear him, and perhaps that's interpreted in his allegedly inebriated state as some sort of aggression, and that's when the physical altercation began. Okay, so I think this is it. No, that's not it. Hold on, I do have it here. I got it here. Here it comes. Here it is. This is from the New York Post. This is some surveillance footage. There's apparently body cam footage and a bunch of other stuff not released yet. So here he is about to come around the corner. Now imagine he's been stabbed was it 3 times? Do you know? I can't remember. 3 times? I don't remember. But I think it was multiple times. Anyway, so here he is with stab wounds. I mean, I might walk like that if I had a couple of drinks. It doesn't look affected much at all.
Yeah.
Maybe
Yeah,
because he's
but
an
no, you can see
athlete.
that he's holding. You can see he's holding his sod.
Oh
and
yeah, I
whatever.
got a hole.
Or
You got a hole in yourself.
Yeah.
Yeah, you're gonna reach for
We're
that.
definitely going to reach for that. And there's a huge affidavit that then was supplemented today. And we're not going to go through it all, but we will go through it in a whole show because I think it's really important because the affidavit lays out what we expect will be the defense, right? In this case. Well, I was
Sure.
self-defense here
Sure.
and all.
Uh-oh.
But
Oh.
what?
Too much noise.
Too much
Yes.
noise with regard. But we have a picture.
Back.
And
Hold on.
okay.
Oh my God. Oh my God. There we go. Okay. Pardon the interruption.
Okay,
So
no,
yeah,
no
it's a crazy story. We haven't heard the end of it, that's for sure. And for those who know, Mark Sanchez is now an analyst with Fox, and he was in town to do the Indianapolis Colts game. He was replaced last minute, and the network has not said yet what they plan to do. They are investigating.
Yeah, no, they're
Let's just
investigating.
say I can't imagine that this ends well for his broadcasting career.
Or any career that he may have at this point. He is represented, and I will say that he is presumed innocent. He is represented by Boyles, Viana, Lukemeyer, Baldwin, and Webb. And they would not be releasing a comment at this time. But we're going to devote pretty much almost a whole show, if not most of a show, to this one day this week. We want to wait and see about whether or not there's any blood alcohol levels with Sanchez that's going to be released. And we want to wait and get the second affidavit because the first one's about 9 pages long. Only page 2 and 3 are the most important pages.
It's an amazing story. Yeah. So I think sooner rather than later, we'll get into this, depending on what new revelations there might be. But
right.
it is a fascinating legal story, and obviously the People magazine element is fascinating as well.
Right. And remember, Sanchez initially was considered critical and then moved to stable, but the victim,
and then released.
He's been released.
Released.
The victim is still in the hospital with some severe injuries, and we will have to put a card that it shows that this is going to, this could be very, very
traumatic. Triggering.
Triggering.
Apparently, he got kind of body slammed against the wall, and then there were some punches, and apparently got hit in the side of the face. To his teeth kind of came through his cheek because he was hit so hard. I mean, just not to get too graphic, but that was the kind of pummeling that was taking place.
Yeah.
And we don't know where the knife came from, how that happened. None of that. It's all mystery at this point.
Anyhow, we will be talking about it later this week on Justice Served TV, along with a lot of the next 2 weeks has a lot of surprises for you all. So stay tuned. We'll be announcing them pretty much every day. Missy will be announcing them in the morning for the next day. So we'll keep you notified, and including next week, which we have some very big surprises. So. Even Michael doesn't know.
No, I don't. I try not to. I try to follow the mushroom theory here. Just put me in the closet, feed me. Okay. Have a great night. That's going to do it for us here. Michael Bryant here, Linda Kenney Baden. I did this and I looked at the video and I was pointed. Even though this looks to me like I'm pointing the right way, I'm pointing the wrong way. Am I? Am I pointing the wrong way?
Yes, you are.
This is the right way.
There you go. That's right.
And what I'm seeing, that's backwards. That's Linda Kenney Baden. This is Justice Served TV. Please try to do the right.